Hey everyone, this is Karinne Sisler. This is my project on testamentary capacity. I do have a bit of a cold right now, so please pardon me if I sound a little nasally. Okay, so the biggest thing that I had a question about was what is testamentary capacity? So, testamentary capacity is a fundamental concept in the field of probate law, which refers to an individual's legal and mental ability to make or alter a valid will. This principle serves to protect both the integrity of the testator, their intentions, and the interests of potential heirs or beneficiaries by preventing fraudulent or coerced wills from being executed. This notion ensures that the testator, the person creating the will, possesses sufficient understanding and competency at the time of drafting their testamentary document. Understanding testamentary capacity is crucial for legal practitioners as it directly impacts whether a will can be upheld in court. So, how do you establish testamentary capacity? Well, several criteria must be met according to common law standards. Number one, the testator must comprehend the nature and effect of making a will. This means that they should understand that they are creating a document that disposes of their property upon their death. Secondly, they must recognize and appreciate the extent of their estate, which involves having knowledge about what assets they own and how these might be distributed. Thirdly, there needs to be an awareness of who constitutes natural beneficiaries, such as, close family members like brothers, sisters, children, etc., and how these individuals relate to them, like I just said. Lastly, it is essential that no mental disorder or delusion impairs their judgment concerning these matters at the time when the will is executed. So, this is how testamentary capacity works. Mental health clinicians interview the testator, the individual who made the will, along with relevant witnesses or others familiar with the circumstances surrounding its execution when he or she is still alive, when the testator is still alive. By using this method, examiners can obtain direct evidence about the testator's mental and emotional well-being at a specific time, thereby determining their legal capacity. When the testator has died, evaluators must conduct after-the-fact inquiries to reconstruct the individual's mental state at the time of signing the will. So, testamentary capacity after the testator has died is inherently more challenging because it relies on indirect sources such as medical records, witness testimony, and other documentary evidence rather than direct interaction with the subject. Retrospective evaluations require clinicians to analyze these materials carefully to infer whether testamentary capacity was present when decisions were made regarding estate planning. Despite these difficulties, such inquiries are essential for ensuring that wills admitted to probate reflect genuine intentions formed under sound legal competency. So the legal requirements of testamentary capacity state that the requirement that testators be competent is a fundamental principle in the law of wills, often succinctly expressed by the phrase that they must be of sound mind. This standard serves as a safeguard to ensure that individuals creating wills do so with sufficient mental capacity to understand the implications of their decisions. Courts do not require perfect knowledge or flawless reasoning from testators. The legal threshold for testamentary capacity is intentionally low, reflecting an understanding that many individuals may experience some degree of cognitive decline or memory impairment without losing the ability to make valid wills. We are talking about most of the time people who are relatively elderly, and so their knowledge of the situation might be a little bit on the decline, but as long as they are of sound mind, that should be enough. So, for example, it is neither necessarily nor expected that a testator recall every single detail about all property holdings when executing a will. Also, forgetfulness concerning distant relatives does not automatically invalidate a will's exclusion of such individuals. People who fail to include a distant family member because they simply forgot about them often have their wills upheld by courts instead of being declared invalid because of their incapacity. In this case, the court recognized that human memory can be imperfect without negating an individual's overall understanding of the intentions. So, what about mental illness and capacity? It is true that mental illness is often stigmatized and that it is associated with cognitive impairment. However, its existence alone does not necessarily imply that a person cannot execute a valid will. Psychiatric conditions vary widely in severity and manifestation, as well as in the degree to which individuals are capable of retaining function in the face of these conditions. In light of this, the legal system emphasizes an assessment of a person's mental abilities rather than their diagnosis or medical history alone at the time of making their will. So, certain behaviors or beliefs held by testators do not inherently negate testamentary capacity either. Prejudice or dislike against specific individuals, even if unfounded, does not amount to incapacity, nor does suspicion that others seek to harm them. Such attributes may reflect personal biases or paranoia, but they do not necessarily impair comprehension or judgment regarding estate distribution. In this way, the law distinguishes between deviations in decision-making and true incapacity, safeguarding autonomy while preventing exploitation. So speaking of bias, prejudice, and maybe the fear of someone harming them, this is the case study of Miss Kohler. Miss Kohler bequeathed only $1 to her sole child, Miss Rogers, while leaving the majority of a sizable estate to a church. Presents a complex interplay of familiar discord and testamentary intent. The controversy surrounding the distribution stems largely from Miss Kohler's expressed reasons for such an unusual allocation during court testimony, revealing deep-seated personal grievances and perceptions that significantly influence her decision-making process. The situation invites critical examination of the factors that shaped Miss Kohler's testimony, disposition, and the implications for which inheritance law and family dynamics. So, her testimony elucidates several key elements contributing to her estrangement from Miss Rogers and her subsequent exclusion from the bulk of the estate. She cited long-standing interpersonal conflicts with her daughter, particularly during their cohabitation with the Rogers family, where she was compelled to undertake tasks against her will. Additionally, she recounted an incident revolving Miss Rogers' husband making derogatory remarks against Germans, a detail underscoring ethnic tensions given Miss Kohler's German heritage, and criticized what she perceived as a lack of religious fervor within the Rogers household. Most notably, she accused Miss Rogers of attempting to inflict harm by placing glass in her pudding, an allegation that profoundly affected their relationship and likely solidified her resolve to favor the church in her will. This case highlights significant issues related to testamentary capacity and undue influence arising from personal animosities and misperceptions within families facing intra-generational conflicts over inheritance rights. The persistence of erroneous beliefs by testators, such as Miss Kohler, can lead to outcomes that appear inequitable or irrational from an external viewpoint, but reflect deeply held subjective experiences influencing testamentary freedom under law. So, what is undue influence? Unlike questions of testamentary capacity, which focus on the mental ability of the testator to understand and make decisions, undue influence centers on whether an external party exerted excessive pressure or manipulation that skew the distribution of property in a way that does not reflect the true intentions of the testator. Courts across various jurisdictions apply differing standards, but generally they seek to establish four core elements: a susceptible testator, an opportunity for another person to exert influence, evidence that improper influence was exercised or attempted, and a resulting effect demonstrating that such influence altered the testamentary disposition. So, something important to note is that in most cases, when testamentary capacity is evaluated, the subject has died, which makes it distinct from other capacities. In many cases, the best evidence of capacity, the testator himself, is not available to clinicians. Unlike evaluations conducted while a person is alive, where direct interaction provides crucial insight into mental state and cognitive functioning, post-mortem assessments must rely on indirect sources. As a result, clinicians must collect information from friends, family members, acquaintances, medical records, and any other materials that might provide insight into the testator's condition at the time of the execution of the will. Due to this reliance on secondary sources, sources, accuracy, and completeness are inherent challenges. So, in recent years, courts have increasingly encountered will contests grounded in allegations of testamentary incapacity and undue influence. This trend can be attributed to several interrelated social and demographic factors. One significant contributor is the growing magnitude of intergenerational wealth transfers, which often involve substantial assets that motivate disputes among heirs. Additionally, the prevalence of blended family structures has introduced complexities in inheritance matters, as step relations and half-siblings may engender heightened familial tensions and contestations. Furthermore, an aging population with a rising incidence of cognitive impairments, such as dementia, has escalated concerns regarding the mental capacity of testators at the time they execute their wills. These elements collectively create a fertile environment for legal challenges predicated on questions about the validity of testamentary documents. Ultimately, as courts grapple with an increasing volume of will disputes involving allegations of incapacity or undue influence, it is imperative to critically assess both legal standards and clinical contributions to these matters. Recognizing the limitations inherent in psychiatric assessments within a legal framework ensures that determinations about testamentary validity remain grounded in relevant criteria, rather than potentially misleading medical interpretations. By balancing empirical facts with judicious expert involvement, when warranted, judicial processes can better safeguard against improper invalidation of wills while protecting vulnerable individuals from exploitation. So this is my media link. It is a video from a law firm. I want to say they're in Australia, but it is a really good video to watch if you want like a baseline on testamentary capacity. So I would 100% recommend watching this. It's a little over 10 minutes, so hopefully that's okay. So a quick little discussion question. To what extent do you believe testamentary capacity should be evaluated? And when do you believe incapacity should be argued? I'm curious to see what your thoughts are. And then this is my reference. I used only the textbook that was assigned to this class, and this is the end of my slideshow.